You may be seated.
All right. Which one do we have up first, please? Number three.
Mr. Bales.
We've got somebody on court call, yes.
Mr. Bales.
There's a court reporter here.
Okay.
Thank you for making a telephonic court appearance. Your court call or court conference operator will be with you momentarily. Please ensure that you are dialing in from a landline and be prepared to provide your name, the name of your judge, and any attorney substitution information to the operator.
Can the court reporter hear that?
And
Just checking.
the line for the next available.
Good morning. May I have the name of your court?
Yes, this is Judge Thornton from the 11th Judicial Circuit of Florida.
Thank you. One moment.
I'm only looking for one lawyer at this time, and that's Mr. Bales.
Okay, just one moment.
Thanks.
And you're live with Mr. Bales.
Okay. All right, Mr. Bales.
Yes, good morning, Your Honor.
All right, good morning. We're here on Digital Integrators versus Carpena, 11-8584. Let me have appearances, please. I'm going to start with you on the phone, Mr. Bales.
Yes, co-counsel for the plaintiff, Digital Integrators Corporation.
All right, and then here in the courtroom.
Martin Nathan, co-counsel with Mr. Bales for Plaintiff Digital.
Good morning, Your Honor. My police court, Robert Keller, on behalf of Marcelo Kim, the defendant, one of the defendants in the underlying civil litigation, and on behalf of Marcelo Kim and Yoon Lee as counter-claimants.
Okay.
And good morning, Your Honor. Douglas Melamed on behalf of the counter-defendant Digital Integrators and third-party defendant Paul Chen.
Okay. All right. Now, you had styled this as status conference rate deposition dates.
Yes, Your Honor.
Have you all agreed on depots and what's going on and when are they set and that type of thing?
Judge,
Some
you
depots,
see-
not all.
Okay.
Judge, I said it because, interestingly enough, the depositions that needed to be taken by opposing counsels.
Speak up so Mr. Bales can
Sure.
hear you.
Okay.
All right.
You mind if I approach? Judge, I set this on calendar because we've had difficulties insofar as available dates during the week for Paul Chen, who is the corporate representative for Digital. Frankly, I've provided several dates, April 4th, 5th, I believe now the 7th is available, and what I've received were responses wanting to allow me to take the deposition of Mr. Chen on a Saturday. And although I enjoy their company very much, I would prefer a midweek date, and it seems like that was unavailable any of the midweek dates that I've
All right.
provided them.
Tell me who's the issue on the other side? Who is not available?
Well, it depends. Some of them are on some days, some of them aren't.
Okay.
Well, and mind you, Judge, it's important to note that all of the depositions that they have wanted to take, I've made myself available, and we've been able to ascertain and identify midweek dates for all of the depositions.
Okay.
With regard to Mr. Chinen, we were last here on the 14th of March. That same day, we sent Mr. Pellier, and he responded. We sent him about 7 or 8 different dates that we were available to proceed. The next day, and he was complaining about Mr. Chinen, the next day on the 15th, one day later, we said Mr. Chinen is available on April 8th. So the day after we were here, we gave him that date.
April 8th is a Saturday.
On 2 different occasions, we have more than 2. We have email from Mr. Pellier saying Saturdays are good if necessary. We appreciated that, but when we gave him this date, that was no good. So what he did was his response was April 5th or April 6th.
When are we set for trial?
May.
the last week, May 22nd.
You know what? I'm not going to.
You shouldn't have
I'm
to
not
hear
getting
this.
in the middle of this. Seriously, I'm not going to get in the middle of this. I'll talk about it with you all on the 31st on Friday when we have the motion for summary judgment. If you all have it, you better settle it by that point. You better have the issue resolved and worked out by that point. Seriously,
What we'd like to
we're
do...
going in May. It's not going to happen. It's not going to get continued. So
What we'd
please
like to do
work it
is
out.
leave from here and work out the dates, if possible. Meaning today.
All right. Well, you know what? You can go out in the hall and do that,
Good
and then come
idea.
right back in and tell me when.
One other matter. This Friday, we've renewed, based on recent events regarding Mr. Carpena, we've renewed and refiled the motion to strike his pleadings for fraud on the court. We would like to argue that as well this Friday.
There's only a half an hour set aside. I mean,
Oh.
I have other matters that are scheduled before and after.
I was constrained to ask. I understand. We will proceed as scheduled. Thank
Judge,
you.
Okay.
there's another issue. If I may, if not, we can address it on
But
Friday.
wait, there's more.
Yes.
Yes.
There's always more in this case. Judge, under complex business litigation rule 6.3, it's discovery with respect to expert witnesses. There's an obligation to exchange information, namely expert reports and/or the basis upon which the conclusion or the reports are based. I've made 2, if not 3, requests for the reports, and the latest response that I received was that the rules don't call for the providing of those reports or that information. So I don't know if you'd like to address it today, or if you want to address it on Friday or some other day, but
Yeah, I mean,
basically, Judge,
there are a few people here. We have a motion calendar that's scheduled. It wasn't on the calendar. You haven't filed anything. I haven't read anything. I'm not going to address that
That's
in the
fine, Judge.
blind.
We'll see you Friday,
So,
Judge.
You know, but please talk about that issue now, also out in the hall. Really, when you're scheduling it, please.
Thank you, Judge.
Okay.
We'll see you
Thanks.
Friday.
All right. Thank you, Mr. Bales.
Thank you, Your Honor.
Number 6, court call.
Your Honor.
I have Mr. Arnold and Mr. Linero that are supposed to be available by phone this morning.
Yes.
That's correct, Your Honor. Reed Arnold here on behalf of J-Tech Security.
Okay, and then
And we'll-
and Mr. Linero also?
Yes, on behalf of J&J Fire Protection.
Okay, all right, good.
Judge, have a nice day.
Thank you. All right, number 6.
Still waiting on one more
On New National, we're waiting for another party.
All right, let's get started. As soon as he walks in, I'm sure it'll be perfect timing. All right, we're here on New National versus Reliance 15-6120. Let me start on the phone with appearances, please.
Yes, Reed Arnold here on behalf of J-Tech Security.
Okay.
And William Linero on behalf of J&J Fire Protection.
Okay. And then here in the courtroom.
Michael Pardo on behalf of New National LLC.
All right.
Harry Rose, Houston Miller on behalf of Nichols Brownsworth, Wolf and Associates, and Stephen Feller, PEPL, and Stephen Feller Individual.
Okay.
Michael Stearns on behalf of Fosco Electric.
All right.
Dean Myers, Fred Bush LLC.
Okay.
And not in the courtroom, who I understand is in the elevator, is Gavin Caddy, who will be coming on behalf of Reliance Construction.
Okay. All right.
Actually, this gives us an opportunity, Your Honor, for a housekeeping matter.
Well, if we could do, I'd like to do the motion on the expert first to see if that needs to be changed at all in terms of the time
So,
frame.
well, that's true. I mean,
We
he's
haven't
the only.
We haven't agreed on our motion for, to compel. We do have an agreement
But,
for dates.
Okay.
but based upon the other motion that's before the court, we're just going to see if that affects this agreed order in terms of the timing in any way.
Okay. All right. All right. What are the other matters that we got scheduled?
And what was scheduled was point.
Yeah, I
plaintiffs-
think we have the protective order.
Go ahead.
That's your motion.
the motion for protective order as to the,
No, that was
the
the, on the,
accountant?
yes, on the accountant.
I believe this is something that didn't make calendar, that's my understanding, but is this something that could be handled by the magistrate or by the court?
I think we said it on,
I have it, I've read it.
Okay.
yeah.
The protective order is based upon a subpoena ducis tecum, or notice of non-party production, to the hotel's accountant. Simultaneously with that notice of non-party production, the architect served a request for production directly to the hotel, seeking essentially the same information. And the basis of our notice of non-party production is, one, the statute, which provides for...
That's a non-testifying expert witness, number one.
Non-testifying
And then number two, it's the accountant client
That's absolutely correct, Your
and
Honor.
privilege that we're talking about. So tell me why
Respectfully, Your Honor, this was both discovery requests were served days after the motion to add the new expert for essentially
I know, but what's the
delay damages
what's the prejudice?
of not ultimately either. What are you asking? I'm sorry.
Well, all right. Tell me why I shouldn't grant the protective
The
order.
case law does seem to support that an accountant
Okay.
privilege. However, I would say that the intention was to get the records that we have not been provided, and it is waived to the extent that they are going to be relying upon them in trial as a basis for their damages. But
Well, I mean,
I understand.
We're not going to, to
What
my
has-
knowledge, we're not calling anyone from that firm to testify as to the hotel's records.
okay.
Well, it is the records that we were seeking, and I don't.
There's
I don't
an
know if your
outstanding
accountant
request
is
for
a-
production, and we are in the process of responding and providing those documents in due course.
Okay. Well, I mean, I'll rule on that separately.
If
And
they
I'll-
don't provide.
Right. I mean, I'm sure you'll file your motion if they don't provide it, and I'll rule on it at that particular time. But as far as the motion for protective order, it's granted. Okay.
Thank you, Your Honor.
The next item, Your Honor, is National's motion for leave to add an expert witness. Very briefly, this is an action, as you know.
I'm going to grant it. There's no prejudice. There's no prejudice. You can take the depot. You can do what needs to be done. There's no prejudice. I mean, that's the only issue as far as prejudice.
Your Honor, if I may, there's one more issue. They're attempting to add an additional expert, and there's 4 allowed by the case management conference. This would be the 5th.
I know. I'm going to let them do it. I mean, it's appropriate. It may be somewhat late in the game, but the depot can be taken. The disclosures, made. Everything's going to be.
Respectfully, Your Honor, the plaintiff who is, I
Tell me
assume has known about
when are we
this
set for
the whole
trial?
time.
When are we set for trial?
August 14th.
What's the prejudice?
Judge,
The prejudice is the damages we've taken 25 depositions, and our whole entire basis for the claims against my 2 clients has changed substantially, and the amount of time they're seeking when we are already on trying to get all of our fact and expert discovery completed prior to, we have two weeks set aside every month, and you're
Well,
asking
so
for an
give me-
additional 60 days.
I'm going to make it very easy.
Give me
Today,
give me
you're getting
dates.
the disclosure from the expert today by email.
Okay.
Okay? If the court wants to provide them with 30 days, the court had already enlarged the time for anyone to file us an amended, so if the court wants to enter an order providing for 30 days from today, they're getting the disclosure today. They're getting the information today.
we're getting a disclosure today on an 11th hour change in a damage model from liquidated damages to actual damages. And we all have to go out and hire experts and do additional fact discovery. And understand you're
I
gonna
agree.
allow it, but we need some
I agree.
time.
I agree. And what's wrong with 30 days? I mean, that's a lot of time.
Well,
You're going to get the
I
disclosure
suppose,
today.
Depending on what the disclosure says, perhaps an expert, because we don't have any of the underlying documents for actual damages.
All right. At this particular point, I'm going to grant it. It's going to be provided by today, by email to everybody, and then I'm going to give everybody 30 days at this point, with the understanding that I understand the situation that you all are in. But I'm asking you to please do what you got to do quickly, because I don't want to change that trial date. All right.
Your Honor, we're currently under an agreed order extending the date for defendants to amend their expert disclosures. Will this apply to all of the defendants experts or just a
No.
response?
No. Nice try.
Just
I respect it, the effort, but no. Just this. Okay, do the order, please, and then let me have that and I'll sign it. Okay? Thanks.
Thank you, Your Honor.
And we have an agreed order on the motion to compel the damages.
Yes, that doesn't seem to have been changed, so let me
Yeah.
provide the court with a clean copy.
All right, Mr. Arnold, Mr. Olenero, don't be so obnoxious and obstreperous the next time, please, okay?
Well, everything was argued so eloquently, there was no need for me to talk.
All right.
Thank you, Your Honor.
All right, thank you, guys. All right.
Have a great day.
All right, court call. There should be Mr. Purdy on the phone as well, or can you join him?
Yes, Your Honor.
Mr. Weil as well, Your Honor.
And Mr. Weil also?
Morning, Your Honor.
Is he going to be on?
Yes, Your Honor.
Okay,
Judge will full report on this case.
all right. Hold on.
Oh, no.
Is anybody here on this? We don't have a court report?
I didn't ask for a
Okay.
court report.
Sorry, I said
Mr. Weil, are you there?
Yes.
Good morning, Your Honor. May I proceed?
Yeah, hold on one second.
Good morning, Ron.
Morning.
Okay. Let me just sign these other orders. All right, you all ready?
Yes, Your Honor. Moises Grayson, may you please support?
All right, we're here on Al Guerrero versus Zach.
Your Honor, good morning. I'm here on my motion to declare the plaintiff in default of the settlement agreement because he has taken absolutely no steps to comply with the settlement agreement. He was supposed to, what was termed in the settlement agreement as normalize the houses, meaning pay the taxes, do some repairs to the property so that they could be turned into condominiums so that we could then deliver a deed to the houses to the plaintiff. Somehow, plaintiff seems entirely disinterested in complying with the settlement agreement and the remainder of the houses. This is a compound with 10 houses. I thought it was more, I thought it was 12, but 10 houses. And the plaintiff is supposed to get 4 houses, 5 houses, and my client gets 5. Did you increase the net one there?
Yeah, Carranta's the numbers guy, you know?
Yes.
He's a numbers guy.
And the plaintiff has done absolutely nothing. So we need to declare the plaintiff in breach of the settlement agreement, and we need my client relieved of the obligations under the settlement agreement, and for attorney's fees and costs and everything else that Your Honor would grant us,
Okay.
respectfully.
All right. Mr. Carranta, you want to say anything? No. Mr. Weil?
No, sir.
All right.
Mr. Purdy.
Mr. Purdy?
Yes, good morning, Your Honor.
Good morning.
We strenuously oppose this motion. The motion is completely irregular. I can't tell whether he's moving for summary judgment. He makes vague.
It is unusual, I'll give you that.
With no specifics. The settlement agreement said my client was to diligently take actions, etc. With regard to the regulations. There were no time limits that were set. We contested he's done, quote, absolutely nothing. There have been multiple hearings before Your Honor on the extensive efforts my client has made from Dubai to get the project going in Brazil with difficulties setting up the corporation, etc. So
I know, over what, a couple of years now?
Yeah.
Yes, sir.
All right. Well, listen. When are we scheduled to be back together again?
Thursday, Your Honor, at 2:30.
All right. I'm going to respectfully deny the motion at this particular point. without prejudice. Let's see what happens on Thursday when we have our hearing on the other issue, and we'll all.
Your Honor, if I may just be heard before Your Honor officially denies my motion. These were
Well,
closed
I take it back.
Mhm.
I'll withhold ruling on it. I'll defer ruling on it.
until Thursday?
That's fair. Yeah,
Fair.
I'll do that.
It's good.
Okay, and then let's see what happens on Thursday. Okay, so I'm going to defer on it. I'll just put it on. We'll see everybody here on Thursday anyway. So,
Perfect. Thank
okay.
you.
All right. See you then.
Okay, thank you, Judge.
Thank you.
Thank you,
Thank
Russ.
you all. Okay.
Thank you, Your Honor.
Thank you. Thank you, court call.
Okay. Number 3, you asked them to step aside. They never came back. They left.
No, I know. But they were still gonna. They were gonna.
Oh, and they're gonna call.
Then they're gonna let us know what's going on.
Oh, okay,
Yeah.
perfect.
Yeah. Okay. All right.
That's it.
What?
I have one more thing.
Just when I thought it was safe to go back in the water, Jaws 2.
I know
Yes.
I know Your Honor has made, when in other case management conferences, and I don't remember whether it was done on this one or not, with respect to Jim Worst, who's a principal of the architect, and I think you went to high school?
I went to grade school with him,
Okay.
and then, yes.
So I just wanted to make sure that was, I don't know if it was on this case or not, that's why.
Oh, he's involved in this case? Yeah,
Well,
but I mean, you know,
WW is in-
but I gotta tell you, with all due respect, I mean, the fact that I know the guy from, it's not one of those things that I would disqualify myself because of.
I would never,
But,
I
I
just wanted to
mean,
make sure it was out there.
but I had
prior.
disclosed it previously, and,
You may have.
you know,
Judge,
yes.
also one more, Gavin Caddy here for Alliance. I noticed that in the trial order that we have, Harry Malka is lead counsel. I just wanted to let you know that we've switched that. Should I submit an agreed order? Does it matter?
No, the only thing that it's gonna matter in is when we do the final, well, we've already done when's the final case management conference coming up? For the, I want you to putting,
July.
I think it is, I think you're right. So when that comes up, there's gonna be a place in there where you can, where you
Okay.
can say that. So just put that in there so that I know,
I just didn't want to.
no, there's not, no, there's, no. That's something that's, easily solvable, so that's not that kind of problem, so, okay. All right, thank you all.
I guess they left. They were supposed to decide on a date.
Yeah, they were,
Mike's.
but I also know that they were gonna be back on Friday, because I have them in front of me on Friday on
So
a matter.
excuse?
I think you are.
All right.
My gut says they're not coming back, they're gonna go back to their offices and work on dates.
Okay,
So,
thank you.
all right, thanks. You guys can have the courtroom till 10:30. No, you can stay here if you want to discuss something, because I don't have my next hearing's not till 10:30.
Yeah,
So.
we have the order.
Oh.
Do you have a magistrate's report?
Tanja Smith, judicialist.
Oh, you put it on. Maybe he's coming around here with a direct line for her. The magistrate's report on what?
That's an R&R. It's 63 pages long. Came out yesterday. This
Okay.
is the other one that came out last week.
Oh, these are the ones we were. Okay. Yeah, but it's only 18 pages of
I
real
know,
report.
I know, I
mean,
know.
Exaggerate.
The chart is 45 pages.
Killing.
I know. I exaggerated.
And the other was only 3 pages.
5?
Okay.
Three 371-3960.
All right, and who's there? Is that Barbara? Is it
Melanie?
Oh, Melanie Damien?
Yes.
Okay, all right.
This is Melanie.
Ms. Damien, this is Judge Thornton. How are you?
Hi, Judge Thornton. I apologize for not being there. We didn't calendar
Okay.
the hearing.
All right. I'll tell you what, we're here on Goldberg versus Holland and Knight, 16-808. Let me have appearances, please. I'm going to start with you on the phone, Ms. Damien.
Melanie Damien on behalf of the plaintiff.
Okay.
Your Honor, good morning. Bob Martinez on behalf of the defendants, and with me is my colleague, Lindsay Lasopoulos-Friedman, and also, Your Honor, we have a 3L from the University of Miami Law School. His name is Drew Sarangoulis, who's here with us today.
Excellent, excellent. So, are you taking litigation skills?
No, I was hired as a law clerk recently.
Ah,
So
okay.
I am in lit skills, yes.
All right. Civil or criminal?
Civil.
Okay. All right. Who do you have for pretrial and trial?
For pretrial, I have Phil Nicholas, and then for trial, it's been intermixed, but mostly Judge Huck, Judge Goodman, and Allison Fritz from the U.S. Attorney's Office.
Oh, wow. Wow. Okay, that's a tough group, let me tell you.
Yeah.
Judge Huck used to go on the bench and get there 2 to 3 minutes ahead of time and just sit there and...
He does that,
does. He's impressive. I remember calling him in private practice at night one time. It was about 7:45, and I was going to leave a message with his JA.
He answers.
And he answers. So I said to him, Judge Huck, are you getting overtime? He did not laugh. He can be so serious. Oh my gosh, that's great. Okay, all right, now, well, good for you. You're in a good place.
Thank you.
All right.
Appreciate it.
All right, let's talk about. I guess what we're talking about now is, are we going to keep this date that is really far in the future or not?
Right. So, Your Honor, may it please the court. Here's the problem with keeping the date, because obviously it's set off of different deadlines, and the deadline that is most pressing, the most recent one to hit us, and it's a very significant one, is the discovery cutoff, the fact discovery cutoff, and that's June 30th. To put this in context, we received yesterday, when I just handed the court a copy of the magistrate's R&R. It is 18 pages of narrative, and then it's a chart that is 45 pages long. And that deals with motion to compel, our motions to compel discovery with regards to first and second sets of requests for production that go all the way back to March of last year, a year ago. The first hearing that we had on those motions was in last October. The other R&R that I gave the court, she issued last week, and she issued, it was in connection with the hearing that was held on March 23rd, and it also dealt with motions to compel from both sides. That's a set of different R&Rs. The lengthy R&R, which includes the 45 pages of charts, requires the essence of it. The essence of why we did this whole thing is because the defendants, the plaintiffs, except for one tiny privilege log, haven't really produced a privilege log. They have stood on their position, which they're entitled to, that the court has to overrule first the other objections before they're forced to produce a privilege log. And the court did that yesterday. And I'm sure both sides will take exception to some of the rulings. The R&R yesterday required the following: privilege logs by May 1st. By May 1st. It required their supplemental responses to our requests for production by April 14th, beginning on a rolling basis to be completed by May 22nd. May 22nd. It also requested that the parties propose an ESI protocol, that be done by the end of April. And if we don't agree to one, that we appear before the court for a conference pursuant to Rule 1.200 before Your Honor. So what's going to happen is this, that we will get privilege logs, and there are many documents that the magistrate required the plaintiffs to log. We will get those logs by May 1st. They will be logged, hopefully. And there's going to be a lot of them. And we're going to be moving to compel. And that's going to take some time. And we're not going to start discovery. And I have a discovery game plan of the people that I want to depose, but it's people related to them, not third parties, mostly. So I need these documents. These are critical documents. I have a sense of what they're holding back. The court may grant our motion to compel, maybe not, but we are entitled to file a motion to compel on the items that they've set forth in their privilege log. Ruling on those motions probably won't be had at best until the end of May, maybe the early June. And then that leaves us with a very
Leaves you a good 3-4 weeks of.
Assuming it was flawless and efficient, and we got all the records, and the thing is this, that once I take the deposition of the plaintiffs, I intend to take the deposition of the plaintiffs' principals. And it includes a person who's a lawyer, Mr. Milan, who was involved in the transaction, Mark Milan. And it includes a person who is an accountant, because he was also involved in doing operational work at the property. They're going to give me information that is going to give me leads to take other witnesses. I know that, because they're going to have statements in their records or answers to my questions that will provide those leads. And to do all that in a period of 4 weeks, assuming that everybody could agree to schedules and that the third parties could agree to schedule, would be, frankly, an impossibility based upon our experience with civil litigation in Florida,
Okay.
even
All right,
with the best of intentions.
I'll tell you what, Ms. Damien, let me hear from you as far as, if you both are in agreement, I don't have a problem, with a couple of months or, with extending it a little bit. But let me hear from you, please.
Well, we're not in agreement, Your Honor. We did receive the orders from the magistrate judge. We intend to comply with the orders. We can block all of June for taking depositions if the defendants want to wait until June in order to take their depositions. We don't think that's necessary. We have been proceeding. We have asked for all the depositions that we want to take, and we will have those scheduled in sufficient time to be done with discovery under the court's scheduling order. I think at best, the request for a continuance is premature. We haven't yet produced the privilege log. And one of the things that I think the magistrate was offering is to review those documents in camera, which could substantially make the whole process more efficient. It's less than, I think, 2 bankers' box of documents that have been withheld on the grounds of privilege.
I'm sure she'll be excited about that. It's
well,
only 2
as
bankers'
I understand
boxes.
it, I think that she offered if there were category objections, for example, all documents, all communications between, the client and Mr. Milland related to the transaction. I think that those are